Today we have a special guest, Gabriella de Mauro. I know Gabriella as a lawyer specializing in real estate law. So today we want to discuss estate planning, trusts, best ways of taking care of your property, and the advice from professional, from the lawyer would be very, very valuable. So welcome, Gabriella.
Hi, Roman. Thank you so much for having me.
Wonderful. Gabriella, so why won't we spend a couple minutes introducing yourself? I know a lot of my viewers might be already know you. For those who haven't met with you, haven't used your services, can you introduce yourself and tell me about what you do?
Yeah, sure. So my name is Gabriella Di Mauro. I am an estate planning and business law attorney. I am the founder of the Mauro Law. We are located in the Brickell area in Miami, Florida. And that's kind of me in a nutshell to make it brief.
Fantastic. Well, Gabriella, why won't we dive deeper into real estate planning? So, most of the buyers and sellers, real estate owners, what they typically do, they write a contract, put the property in their own name. So, is there any better ways of holding real estate title? What would be your professional opinion on it?
So, it really depends on the type of property that you are purchasing. So, for example, if it's your first home, if it's your primary residence, there are certain benefits that come with owning that type of property versus whether it's an investment property. Perhaps there's a little bit more planning that we can do. And I'm referring to more the asset protection aspect of what I do, because estate planning is sort of an umbrella term that I like to use. But within estate planning, there's succession planning, right? So you have wills and trusts, things like that. You have asset protection planning, and so in that vein, right, when you own real estate and it's your primary residence, okay, you get something in Florida called the homestead protection, right? And so if you know, default and you become a debtor, right, you have certain protections in Florida, which basically states that most creditors, right, not all creditors, but most creditors cannot collect or cannot basically go against your real estate, your primary residence. Now, the same is not true if, for example, that's an investment property. So if it's not your primary residence, you cannot have another homestead. And so that's where we can sort of plan, and it might not be the best to hold or to own real estate in your own name. There are better ways to protect that property.
All right, so let me make sure I get it clear. If you own it in your own name, you can claim the homestead protection, homestead exemption, and this is how you protect when it's under your name. Tell us what other options consumers have out there. I know we can register it under LLC, it might be registering in a trust. Tell us about other options we have.
So if it's not your primary residence, so it wouldn't have that benefit of that homestead protection, right? That's afforded. That you can have pretty much, you can structure it in a couple of ways. So I guess the first being as husband and wife. So if you're married and you own the property with your spouse as husband and wife, there's something called tenancy by the entirety, which affords protection as long as the potential creditor does not have, let's say, a claim against both spouses. So let's say the husband is the debtor and the wife is not, then that property is going to be protected because both parties are not subject to the suit. Another sort of go-to structure that can protect your real estate investment would be a good old-fashioned LLC, a limited liability company. Most of the time, it has to be structured in a way to get or to claim full advantage of that protection. It's best to formulate it as a multi-member company. But that's another way or another strategy that can help protect your investment property. And I would note that it's very important to sort of respect the proper structuring of an LLC. And what I mean by that is, it's a little bit more than just opening up maybe a company on Sunbiz. You really need to respect the formalities in order to receive that protection. So, you have to have your legal documents in place. You have to have, for example, that bank account completely separate from your personal. And so I would just kind of place that nugget of information that it's very important not only to open up that LLC, but to have it structured correctly.
Absolutely. So you suggest to create LLC just to own that particular piece of real estate.
That's another good point, where if you have multiple investment properties, it could be a good idea to have an LLC per investment property, just because we don't want to put all our eggs in one basket, as I like to tell my clients. So for example, if you get sued, right, and this is where asset protection comes into play. We're trying to protect your assets in case of a potential creditor. And so if your LLC number one gets sued, you do not have your 5 properties in one LLC. We want to diversify the risk. And so that's why I guess it's common, I guess, at this time, that it's known that you should put an investment property per LLC. And that's the reason why. You just don't want to mix all your assets in one sort of LLC entity.
It makes total sense. Great value. So let's talk about estate planning. And we unfortunately die. Everyone's gonna die at some point. So tell us about strategies, how we can benefit from forming a trust and other forms of estate planning.
Yeah, that's the reality of human nature, right? We're all set to expire at one point, and so with estate planning, it's important to I would say work with an attorney that does specifically, or I guess specialize in this area. It's sort of a complex area of law, where there's many tools that we can use to protect your assets and make sure that your heirs, right, receive that asset in a sort of flawless and non-contested manner. And so in the state of Florida, for example, if you own let's say a property in your own name, and you do not implement any other plannings or any other estate plan, that asset unfortunately does not automatically transfer to your heir, right? Let's say in this situation, you're not married and you have, let's say, a child. It's very important to plan accordingly, so that your child will receive your real estate without the need for court intervention. So if you do not plan, okay, the only way that your heir, in this situation, your child, would receive that property is through a process called probate. And so probate is administered in the court. It's a judge administers this process. There are oftentimes attorneys. There is court fees and attorney's fees associated with this process. And so it is a process that your heir would have to initiate in order to receive the property. Now, there are ways to structure your assets so that your heir does receive your property upon your passing automatically, without the need for court involvement, without the need of additional fees and costs and attorneys in the mix of things, especially at that emotional time in the heir's life. You're dealing with unfortunately a loss, a family member, loss of a mother, father, God forbid, a daughter, son. And so the last thing that you really want to be dealing with is sort of administrative tasks and trying to inherit property, which should obviously go to the family member. But unfortunately, that process is most of the time not automatic if you do not plan.
Great advice. So if, let's say, things happens and a person doesn't have a will, What would be the process? Can you help this person? And let's talk about wills for a second. When do you think it's a good time to start thinking about one? We don't expect to die, but when it happens, it's unfortunate. And it happens, we need to prepare for the worst. So give us a little bit of info on that.
Of course. So a will, right, um, is pretty much I think most people are familiar with it, right? But a will is pretty much just a document that it helps you distribute your property in the sense that you on the will say, for example, I, Roman, want my real estate and my whatever other asset, right, to transfer to X heir. So with that will comes what we just spoke about, which is the probate process. So you do not avoid probate by having a will. So you need to submit that will to the probate court. Okay. And so if you pass away with a will or without a will, you're going to be subject to probate court. Okay. The only difference is that with a will, you've made your wishes known. Okay. And without a will, your assets will transfer according to Florida law, right? So that's kind of, the difference between having a will and not having a will. You're still subject to probate court. You still need to pay attorney's fees and court fees to receive the property of the deceased. Okay. But with a will, of course, you make your wishes known. And so that process, depending on what type of assets there are, right, in the deceased estate. So if you pass away, for example, with real estate, an investment property, some bank accounts, right, the process can take longer. All right. It's also more susceptible to probably some contested facet. So, perhaps family members are more likely to contest that and maybe disagree on how or who should receive the property. And so I would caution people to kind of take a moment, right, and see what else is out there, right, for estate or succession planning. One of the tools that I always advise my clients of is a trust, right? Because a trust is like a will, because you basically dictate how you want your assets to be distributed. Unlike a will, you're not subject to probate. Your assets are placed into what I like to say, little box. So you think of your trust as a box. And when you expire, and solely when you're expired, does that box close and distribute the assets according to your wishes. And so you avoid the need for probate. You avoid the need for court costs, attorney's fees, and your heirs receive that property automatically.
Exactly. Sounds like there is so many tweaking points, tweaking parts in this process. So where would you advise to talk to a professional attorney like yourself before they start shopping for a house or after?
So it can be before or after. It's very personal. You can, for example, I think it would make sense for you to acquire assets prior to structuring the estate, because in essence, if there's not any assets, then we cannot pretty much distribute anything.
Right.
So, it's not, perhaps you already have a property and you're thinking about purchasing a second one. At that point, we can always add property to a trust. But if you have no property and, this is kind of like your first time purchase of real estate or whatnot, then, I wouldn't see there's any harm in, purchasing the property, get situated, obviously enjoy that, right? And then, definitely don't take too much of a break. But that it's completely fine to plan after that fact.
Well, so if let's say I buy a house under my name and then I realize from this podcast that I should have it in the trust or LLC, you can still assist them when they already purchased it, changing the entity, right?
So, I mean, with your primary residence, I don't see too much of hold up, right? Now, when you're purchasing an investment property, you have to make sure that, it's always best to maybe purchase already within that entity. For example, maybe purchase under that LLC so that way you can avoid second deed. If you purchase the second house, right, an investment property under your own name, and then you talk to Gabriela and she says, "What are you doing? That's your second home. If you get sued, that house is not protected. We should transfer to an LLC." There are some details that we would need to comb through to make sure that that transfer of the property from client's name to the LLC doesn't trigger any sort of taxes or anything like that. For example, if you have a mortgage on that property, sometimes you need to request permission from the bank, the lender. So there's that aspect of things. But for the most part, you can acquire assets and then we will work through the asset and structure accordingly.
Fantastic. All right. Well, sounds like you're one-stop shop and everything that consumers would need from a lawyer, you can provide them. So to wrap this podcast up, what would be your message to the viewers who would be watching this podcast on YouTube, on Facebook? What would be your message? How they would better protect themselves and where to start?
So I guess my message would be, I know that this is not the funnest of topics. I'm well aware. But with this area, unfortunately, it's a little bit, when you need this structure and you don't have it, it gets very complicated very quickly, as opposed to, perhaps you have some time on your hands and that would be the time to sort of implement any structuring, because once you sort of need it, it's a little bit late to go back and structure, if that makes any sense. And
It
so
makes little sense.
that's sort of the message. And it's not as on the law side, it's complex, but for the client, it's very streamlined. And if you're working with a professional that really dedicates their practice to estate planning, business law, and this particular niche, it will be, I promise, very smooth, and it's not as scary as it may seem, and it's very important.
Wonderful. So before I let you go, how can my viewers, how watchers of this podcast can contact you and ask for service?
Yeah, sure. So I am pretty active on social media. My handle on Instagram is Mauro Law. You can send me an email, info@dmauro.law. You can give us a call at the office number 305-684-1515. But if you go to my Instagram, all that information is on my profile. You'll have my website, you'll have my email, and you can even send me a direct message and I can respond that way.
Fantastic. All right. Thank you so much for joining me on this podcast. Hope everyone learned a lot as much as I did. And I want to thank you again, Gabriella. Have a wonderful day.
Likewise. Thank you, Roman, for having me.